Hello, my name is Julie Williams. I'm a registered migration agent with Migration Down Under, and I'm going to be talking to you today about partner visas. Partner visas, they are quite complex. People feel that just because they are in a relationship, they can apply. And relationships are much more complex when it comes to immigration. Whilst we're not denying that you're in a relationship, what you need to be able to prove to the department is to show that you're either in a committed de facto spousal relationship or a committed married relationship. And that can either be same-sex or heterosexual. Either is perfectly acceptable now that the Marriage Act has accepted same-sex couples in Australia, which is wonderful news. Now, for partner visas, there's a variety of options, whether you're onshore or offshore. The processing for offshore applications, interestingly, depending on the overseas branch, can often be a lot quicker than applications lodged here in Australia. And applications lodged offshore are Prospective Marriage Visa, the subclass 300, which can only be lodged offshore, or the subclass 309 or 100, based on a married or de facto spousal relationship. So let's look at offshore applications to begin with. Now, offshore applications that, dependent on your circumstances, can be whether you are engaged to be married, whether you are living together overseas in a de facto relationship, or living together overseas in a married relationship, or perhaps you've actually got married and are living in two separate countries. It may have been an arranged marriage whereby you got married and then your partner, your Australian citizen partner or a permanent resident, had to return back to Australia for work reasons. All those are acceptable. Now, the Prospective Marriage, the 300 visa, is for people that are looking at getting married. You don't have to get married before you enter Australia. In fact, the requirement for this particular visa is that you don't get married until after the grant of your visa and within the 9-month time frame that the visa is granted. Now, the Prospective Marriage Visa, what it requires is that you've got a commitment to get married within 9 months of the grant of your visa, because the visa, once granted, is for the duration of 9 months. And you must at least enter Australia once after the grant of the visa and prior to you getting married. Now, there's no restriction of where you get married. You can get married in Australia or overseas. What the 300 visa allows you to do is to come into Australia with full work rights. You don't have any access to our healthcare, national healthcare scheme, Medicare, but you have multiple re-entry, which means you can travel in and out of Australia whilst on this visa, and obviously you can live with your Australian partner, which is great news. Now, these Prospective Marriage Visas often are processed a lot quicker and a lot sooner than married or de facto spousal relationships. And they also don't require as much documentation, because you don't have to provide evidence that you're actually living together for the Prospective Marriage Visa. It suits a lot of people whereby they are separated, living in different countries, and it is difficult for the overseas applicant to come out to Australia, even on a visitor visa, to come and visit. And with the Australian partner, they're often working or have commitments here in Australia that they can't just pack up and be with the applicant overseas. So the Prospective Marriage Visa is a really good one for those that are separated and have a genuine plan to get married within that 9-month period. And once you are married, what it does allow you then to lodge a further partner visa application based on you being married. You must do that within the 9-month period, and whilst the processing may take longer than your visa, what will happen, you'll be given a bridging visa, which will bridge you over when your current Prospective Marriage Visa expires and before your partner visa is approved. It will bridge you over to allow you to legally continue living and working here in Australia. It also does, once you do lodge the partner visa, provide you with access to our national healthcare scheme, Medicare. What happens with all partner visa applications, not the 300 that we've just spoken about, 309 or the 820, Now, the partner visa, what they will do is assess your relationship under either de facto or married. If you have been in a married or de facto relationship for a minimum of 3 years, which means that you've been living together for a minimum of 3 years as a married or de facto couple, they will assess your application and possibly grant you permanent residency straight away, rather than going through a 2-step process. Most often, the requirement is a 2-step process because many people don't have evidence, or they haven't been in a relationship, or at least a de facto or married relationship, for the length of 3 years. You may have known someone perhaps for 5 years and been in a boyfriend-girlfriend or same-sex relationship, but not necessarily in a de facto or married relationship for that length of time. You may have only recently got married, you may have only recently become moved in together and become a de facto, in a committed de facto relationship. So what the department will do, they will assess your application to see that you are in a genuine relationship, and then they will grant you what's called a provisional visa. So if that's offshore, it's a 309. If it's onshore, it's an 820. And that provisional visa will allow you to come to Australia with full work rights, living here, multiple re-entry, so you can travel in and out of Australia on that particular visa. And it will also give you access to our national healthcare scheme, Medicare. And that visa will be indefinite until your permanent residency has been decided. Now, when they look at the permanent residency stage, they view that 2 years from the date of lodgement. Not 2 years the date of your provisional visa was granted, but 2 years from the date of lodgement. So if you've lodged your application, say the 1st of January 2018, and you have your visa granted in September 2018, they will assess your permanent residency eligibility from the 1st of January 2020. And what they will require at that second stage is further evidence to show that you're still living together as either in a married or de facto relationship. And they will require updated evidence of that relationship to show that you are living together and recognised as a genuine couple. Now, the offshore applications, as I mentioned, can be a lot quicker than the onshore. The standard processing balloons out from anywhere from 12 months to 24 months. So I guess the advantage of the processing, if it does take longer and they are only assessing you and you only meeting the provisional process, it may mean that if your first stage takes 18 months, then you've only got another 6 months to wait until you're eligible for permanent residency. But be aware, the permanent residency stage also takes a significant amount of time. The reason being is that second stage means that you're already here in Australia, living with your partner, and you've got full work rights, full access to travelling in and out. So they don't give priority to that simply because they don't have the resources. So they put the priority into those that are still waiting for the visa, and the second stage may take a little longer. It just depends on the time of year, the volume that's in the pipeline. So you can be looking from the day that you lodge your visa application to when you get permanent residency. Could take as much as 3 years for you to become a permanent resident. It doesn't mean that it's going to take 3 years for you to get that first visa to allow you to come and live in Australia or remain in Australia if you're here. It just means the entire process from beginning to end to get your permanent residency could take 3 years. So just be aware of that. With onshore applications, you can't lodge a prospective marriage visa onshore. That's only an offshore application. With the onshore, that's for people that are here living in Australia with their partner already. You may be already you're obviously on a temporary visa. That could be a working holiday visa, could be a student visa, it may simply just be a visitor visa. It might be a temporary skilled work visa. What will happen, if you have been living as a de facto couple, or you've been living as a married couple, then you can lodge what's referred to as a subclass 820 partner visa. And same process as the offshore. They will look and consider permanent residency, and if you haven't been living together for 3 years or more in a married or de facto relationship, then they will grant the provisional visa first and then reconsider the permanent residency after 2 years of when you've lodged it. Now that all changes if you have children, of course, and that goes for offshore applications. If you're in a relationship and have children and have been left in a relationship for 2 years and you've got children, then they will also consider permanent residency and you don't have to go through that two-step process. Now, with the onshore application, what will happen once you have lodged a valid onshore application, if you are here on a substantive visa, you will be granted with issued with a bridging visa A. That just sits in the background and it doesn't come into effect until your current visa expires. So, for example, if you're here on a visitor visa and you've only got 2 months before your visa expires, and the partner visa is going to take a minimum of 12 months to process, then once the visitor visa expires, the bridging visa will automatically kick in and allow you to legally live here in Australia with your partner. The beauty of the bridging visa A also gives you full work rights and unrestricted work rights whilst you're waiting for that partner visa to process. And again, upon lodgement, you get access to Medicare and National Healthcare Scheme. Just be aware, with the bridging visa, many people make the mistake of thinking, oh great, I've lodged the visa, I'm on a bridging visa. That lodgement doesn't override your current visa. The only thing that overrides your current visa is the grant of the partner visa or another visa. So if you're on a student visa, for example, you've got another 18 months to go, you really don't like your course, and you think I'll lodge a partner visa to get off that student visa, that won't work because the partner visa could take 12 months and you must continue adhering to the visa conditions of your current visa. So if you're a student, you've got to continue meeting those conditions and studying, otherwise you can risk cancellation, which will then cause trouble with your current partner visa. It's the same if you're on a 457 or a 482 visa and you want to move employers, the same thing, that condition still stands, and the bridging visa will only come in when the current temporary visa you're on expires. So just be aware of that because many people do make a mistake. There are ways to overcome that, but possibly too complex to go into this presentation at the moment, and it's probably something, if you do wish to find out more about, that you do contact us to find out more about that. Now, the partner visas, a lot of people, I guess, sort of complain about the amount of documentation that you've got to provide, but it's really often quite difficult, even if you've been in a relationship for many years, to provide the relevant documents that the department require. And the reason being is we understand that every relationship is an individual relationship, and we're not going to box you in to the same as everybody else. And we understand that you're not all going to join your finances together, you're not going to have a joint bank account, but there are certain aspects of a relationship, if you are in a genuine committed relationship, either de facto or married, that you do have certain evidence to support that. They look at the 4 pillars and they look at your commitment, your financial commitment. You may not share a joint bank account, but what other financial commitments do you have? Maybe it's a mortgage, maybe it's a joint lease together, maybe it's joint ownership of a car. There's all sorts of things that you can have to show that evidence of financial commitment. Then they look at the social aspects of your relationship. Usually the easiest for most people. The social aspects is recognition by your family and friends that you are in a genuine committed spousal relationship. Now, they're not just saying, yes, you make a fabulous couple, and we see them holding hands and you're often always going out to dinner and they're genuinely in love. Of course, that's all part of a relationship, but it's not what constitutes a de facto relationship. Married, is usually obvious to everyone that you're living together and you've got certain commitments. But this de facto relationship is exactly the same level of commitment as a married relationship. The de facto relationship is that you're living together as a committed couple, not just flatmates, not just boyfriend, girlfriend sharing a house with some other people. It's a committed de facto relationship. So you've got to show the same level of evidence that you would show as if you're married. Now, so we've gone through financial, social. The other area is household, nature of the household. So, you know, how do you run your household? Who looks after the payments of bills? Perhaps you're in a house, not a unit. Maybe it's yours. Who looks after the maintenance? Who looks after putting out the garbage? Who does the washing up? Who does the cooking? That's all the things they want to see, how you operate and run your household. Who pays the bills? And, you know, there's a wide variety of things you can do to provide evidence for that. And then the last is the level of commitment to one another. So what are your future plans? What have you already committed to each other? Maybe you've committed to getting a dog. Who knows? It can be any level of commitment. You don't have to say, yes, we're going to have children, buy a house and live happily ever after. That's not what makes up an everyday relationship these days, and the department understands that. So they want to see what sort of commitments you've got. Maybe that, you know, as simple as what I mentioned, buying a dog or organising to go overseas to spend Christmas with your, you know, your partner's family at Christmas time. Those are the sort of things they want to see. So there's a wide variety of examples. With the de facto spousal relationship, you've got to show that you have been living together for a minimum of 12 months, and that evidence of the 12 months can't just be photographs and stat decks. It has to be fairly substantive evidence to show that external organisations such as government bodies recognise your relationship. So maybe you've registered your relationship, maybe you know, you've got your tax, you've declared that you're in a de facto relationship, and you've got who your partner is. Now, in certain states in Australia and certain countries overseas, if you're doing an offshore application, recognise the registration of a de facto relationship. And so if you do register your relationship, it's the same for if you get married. You don't have to actually provide evidence of 12 months cohabitation or 12 months living together. That sort of overrides the need for the 12 months. But be aware that just because you've registered your relationship, and if you've only been in a relationship, say, for 4 months, it's not necessarily going to succeed, because you do need to show that you're in a genuine committed relationship. And naturally, the longer you have been in a relationship together and the longer the history is of your relationship, will make for a stronger case at the end of the day. So I've tried to sum it up as precisely as I can. As I said, it's quite in-depth, so there's quite a lot of other information there, and probably a few things I've missed, or maybe I haven't answered your questions that you've got burning there. So please don't hesitate in contacting us. It doesn't cost you to ring to pick up the phone call and give us a call, or even send us an email if you're overseas. We have 6 registered migration agents here that are happy and dedicated, as well as experienced, including a couple of them having done their own partner applications for their partners. So we've got not only the experience from our clients, but also personal experience as well. So don't hesitate in giving us a call. Our number is 02 9419 5411. Otherwise, email is info@migrationdownunder.com.